The content presented in this video is intended for commentary, analysis, and educational purposes, and is protected under the principles of fair use as defined by U.S. copyright law.
Is somebody gonna tell me about her head wrap?
Your Honor, I'm not her counsel, but she did say that she has that on for religious purposes.
I will go into my whole how your hair wrap's supposed to be on for religious purposes speech, because I do have a little research under my belt. Okay. All right, I'm ready.
Hello?
Don't say hello. I'm still waiting on you to get ready for court. Don't ever come in my courtroom laying down again. Ma'am, it's not a conversation. There's no need for a response. The court is open for business. That courtroom right here, it's open for business. 421 Madison Street. The court is open for business.
Welcome back to Kangaroo Court Law, where we embark on a riveting journey through the virtual chambers of justice, unraveling the quirkiest tales from the digital courtroom. Today, we've got not one, but two defendants who are about to learn a valuable courtroom lesson. First up, an impatient defendant who's got a bone to pick with his ankle monitor. He claims it's cramping his style at work on the construction site, and he's ready to lay his case before Judge Bryant. And in the second case, we have a female defendant who came to court laying down. She immediately upset Judge Bryant with her body language and attitude, which promptly earned her the right to appear in person because the court is open for business, according to Judge Bryant.
Yes, ma'am.
Oh, I said your name so wrong. I asked them, but I said it wrong. I'm sorry. All right, today is the day set for pretrial conference. How are we proceeding?
Your Honor, it appears that the complainants are not present. So in the absence of what appears to be the absence of the complainants, we're requesting dismissal.
Ritter.
Judge, it's the first scheduling of the pretrial conference. I'm going to ask the court to adjourn the pretrial conference and give the complaining witnesses one more opportunity to appear. I would note, Judge, that I don't see the complaining witnesses in the waiting room at this time.
All right, today is the day set for pretrial conference. The court is going to deny defense counsel's motion for dismissal. I will grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witnesses of their obligation to appear before the court. The matters are set for November the 8th at 8:36. The complaining witnesses are required to appear. Failure of the complaining witnesses to appear will most likely result in the matters being dismissed unless the people have a valid explanation as to why the witnesses did not appear or should not be required to appear. Bond will continue with no contact with the complaining witnesses. Anything further?
Judge, I'm sorry, can I have that date again, please?
November the 8th.
Thank you, Judge. Nothing further from the people.
Your Honor, I would like to address bond.
You may.
It's my understanding that my client does have a tether on. We are asking for the removal of the tether. He is employed at Allied Construction. He has had no tether violations. He understands that he has to appear for court. The issue that he's having is actually
he might have to take off work to appear for court. Okay, go ahead, because he was working and moving and doing all of that today.
No, he understands that he has to appear for court.
But I'm asking you, does he understand that he might have to take off work to appear for court?
Oh.
Yeah, okay, go ahead.
Okay, I understand. So one, he's saying that the tether is extremely tight and is making a mark on his leg. But secondly, with his job, he does work in construction and he works with asphalt. And that involves heat up to about 400 degrees. And the heat drains the battery on the tether quite often and really fast. So he has to stop working a lot of the times to charge the battery because it exacerbates the power that the battery can hold. So we are asking that the tether be removed so that he's able to maintain stable employment. And he understands the no contact order and that he has to appear for court.
Ms. Ritter.
Judge, if the court's inclined to remove the tether, we're going to ask the court to place a no contact order for the complaining witnesses, Ms. Stanrita Tyner and Mr. Daniel Tyner.
All right. The court is going to remove the tether, but not because the heat from the asphalt drains the battery. If he needed to tether, I wouldn't care about that heat from the asphalt. But the court is going to remove the tether. I'm not aware of any tether violations and do not believe that a tether is necessary with respect to the charges. The court is going to remove the tether.
Thank you, Your Honor.
You're welcome. Anything further?
No, thank you, Judge.
Nothing for defense.
All right. Sir, can you pass the phone over to your co-defendant?
Hello.
Is somebody gonna tell me about her head wrap?
Your Honor, I'm not her counsel, but she did say that she has that on for religious purposes.
I will go into my whole how your hair wrap's supposed to be on for religious purposes speech, because I do have a little research under my belt. Okay. All right, I'm ready. This is case number 234496702, the people of the state of Michigan versus first name T-E-A-I-L-Z-A-H, last name Pratt. Defendant is charged with 1 count of assault or assault and battery. And today is the date set for pretrial counsel. Come back on, please. Pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Rakedia Hall on behalf of Tioza Pratt.
Ma'am, state your name.
Tioza Pratt.
Thank you. Today is the date set for pretrial conference. I understand Ms. Pratt is the co-defendant to Mr. He told me his name and I just can't think. Sin. And therefore requires the appointment of counsel, as there may exist a conflict of interest with the representation of both defendants for the defender's office. So the court is going to continue a not guilty plea on behalf of Ms. Pratt, and I will set a pretrial conference for Ms. Pratt for November the 8th, 2023. We're going to put Ms. Pratt on the docket for 8:31, indicating that counsel should have been appointed. Ms. Pratt, we will appoint counsel. We will have counsel appointed to you, and they will be present at the pretrial conference. Additionally, if you want them to be able to talk to you beforehand, then you need to give us your phone number so that we can, your address and phone number so that they can communicate with you prior to the date of your pretrial conference. Do we have contact information for Ms. Pratt, or did you all not? You say yes. Okay, well then we will forward that contact information to the Michigan Indigent Defense Council, and they will appoint counsel for Ms. Pratt. The complaining witnesses are still required to appear as to Ms. Pratt as well on November the 8th. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complainant could not appear or should not be required to appear. Bond will continue. Anything further?
No, thank you, Judge.
No, Your Honor.
Then we're all set, Ms. Pratt. And have a great day. Stay safe.
You too. Thank you.
Thank you.
Judge, I have a complaining witness on there.
I know, I see it. I mean, why you, I see your complaining witness on van.
I was just letting the court know.
Oh, okay. You acting up today. Miss Hall, did you hear the affect in her voice? She's like, I got a complaining witness on van. Did you hear how she said it? I did. Okay, so now she gonna make me skip them. I was go to now she gonna make me skip them. Her complaining witness who came in. Okay, let me bring in Van. They don't have a plus sign. So that means perhaps you all did not speak with them.
I have not.
All right, let me bring them in and send your colleague a message for me to see. I'm gonna start playing. Ms. Van, when I let you into the courtroom just now, you were laying down. Don't do that again. Don't do that again. Don't do that again. I need you to sit up. I need you to take your arm off of your cheek. I need you to sit up. I need you to not be in the bed. I need you to not be laying down on a couch. I need you to get up for court. I need you to get up for court. Hello? Don't say hello. I'm still waiting on you to get ready for court. Don't ever come in my courtroom laying down again. Ma'am, it's not a conversation. There's no need for a response. The court is open for business. That courtroom right here, it's open for business. 421 Madison Street. The court is open for business. There are no beds in there. There are no mattresses. There's nowhere for you to lay down. I need you to get somewhere where you can be seated, stationary, in an upright position, and ready to attend court. And you having an attitude about attending court sitting up is only going to be detrimental to you. It's not going to be detrimental to me. Roll your eyes at me again, and it's only going to be detrimental to you. It's not going to be detrimental to me. Please accept to join the breakout room and wait for a lawyer to come in to speak with you. Do not leave the breakout room until you have spoken with the lawyer. And they're going to help you with how to attend court. They're going to help you with your court demeanor. They're going to help you with the decorum of the court. They're going to help you understand that if you don't know how to attend court on Zoom, that the courtroom is open for business. Pre-COVID, the way we used to come, old-fashioned, old school, come down to the court, get dropped off, catch the bus, drive your car, park your car, walk into the court, go through security, come up to in the elevator to courtroom 339, check in with the court officer and have a seat on the bench. We are open for business. Please accept to join breakout room number 4. Tell Ms. Stevenson to come back, Ms. Hall, though. Actually, I need to do this 3 defendant case right quick. Oh, wait, never mind. Her client might not be on the docket. Is her client even on the docket? Oh, yeah, her client is on the docket.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.